The biography of Mrs. Elsa Smith is she's the founder and principal of the law offices of Elsa W. Smith, LLC. She focuses her practice on wills and estate planning. She counsels individuals, families, and business owners in the creation of wills, trusts, powers of attorney, and advanced directives. She has over 20 years experience as an attorney. She's a native Spanish speaker of Afro-Cuban descent. Elsa holds a Bachelor of Business Administration and Juris Doctorate from the University of Miami. She's licensed in Maryland and the District of Columbia. Mrs. Smith belongs to the Maryland State Bar Association's Estate and Trust Law Section Committee on Diversity and Inclusion. In October 2020, she was a presenter on the Maryland Attorneys General COVID-19 Access to Justice Task Force Virtual Life and Health Planning Community Forum discussing the importance of estate planning. In 2020, she published an article in the Maryland Bar Journal on how estate planning attorneys can leverage technology to serve more diverse populations. She's a proud member of the American Business Women's Association. ABW is a professional development organization. She's the vice president of the organization Maryland Capital Chapter. In 2020, she was chosen as a top 10 businesswoman of ABWA, the fifth in Maryland Capital Chapter's history. Congratulations. Attorney Smith has been a guest on radio, television, webinars, and podcasts. She has a vibrant YouTube channel called Elsa W. Smith Law, dedicated to providing free information on wills and estate planning. She's also an active social media presence on Facebook, LinkedIn, and Instagram. The law offices of Elsa W. Smith, LLC is proudly minority and women-owned. Elsa's passion is empowering women through estate planning. Another firm goal is to stem the loss of generational wealth through proper training. She was recognized as a 2021 Maryland Super Lawyer in the areas of estate planning. The annual Super Lawyers list has become a highly respected legal ranking publication that, ranking publication that rates attorneys from over 70 legal practices areas. Only 5% of all lawyers in Maryland are named to the Super Lawyers list every year. Wow, this is so impressive. And she's here with us this evening. Let us welcome to our AGCI Financial Clinic, Mrs. Elsa W. Smith, Esquire.
Hello, everyone. Hopefully everyone can, oh, wonderful. Hopefully everyone can hear me. Okay, thank you, Pastor Sharon, Pastor Lawrence, thank you so much. Abounding Grace Church International family, thank you so much for having me this evening. I've got a lot of information to share, so I'm just gonna jump right into it. Let me turn this off here. It's a funny thing about technology. It's like all things are pinging and so forth. But I'm glad to see so many of you here. I'm going to start by sharing my screen, and we're going to jump right into it. Let's see. And let's see. Okay. And if you could just give me a thumbs up to let me know that you can see my title screen, please. How to go from overwhelm to empowerment. If you can see that, just let me have a thumbs up or something, or in your reactions, just to make sure, because I don't want to lose it. Okay, great. Okay, wonderful. Thank you, Miss Evans. Thank you. All right. So tonight's topic is how to go from overwhelm to empowerment. Oops. Here we go. You heard a lot about me, but just a couple bullet points. I am the founder and principal of the law offices of Elsa W. Smith. I do have over 20 years of experience as an attorney. I was chosen this year as a super lawyer, and I'm also a member of the Estates and Trust Section Council, which is kind of like the governing body of the Estates and Trust area of the Maryland Bar Association. I'm also a member of its subcommittee, which is on diversity and inclusion. Okay, my commitments to you are threefold tonight. First, I want you to overcome the fear of planning for the unexpected and the fear of, and the feeling of overwhelm when it comes to estate planning. Secondly, I want you to learn how to create stability for loved ones in times of loss. And then lastly, I'd like you to feel empowered to leave a legacy of success for your family. And just as a matter of housekeeping, I'm sure that you will have questions as I go along, asking you to either, I guess, put them in the chat, and one of our moderators will make sure that at the end of the presentation that we answer as many questions as possible. The reason I hold them until the end is usually the questions are answered by something else that I say during the presentation. So you just make sure to either make a note on a notepad if you're taking notes, and you should be taking notes. There's going to be a lot of good information this evening. All right. Here's the agenda for this evening. What is estate planning? The basics. I'm not assuming that anybody on this webinar or anybody watching us on the live stream knows about estate planning. So I'm going to start off by laying a foundation. Then we're going to talk about some considerations for singles, some things that married couples should consider. We're then going to talk about what not having a plan will cost you. And then we'll, towards the end, we'll talk about how you're going to change the narrative in your family. And hopefully that is something that I hope that you do. And then we're going to end up with a very special offer. As my way of saying thank you for your attendance, as I said, I have a special offer for you, and I will share the details at the end of the presentation. And it is only, I have to make sure and listen to the entire presentation in order to take advantage of it. Okay. This does not need to be you, either the young lady or the young man in these photos. This does not need to be you. Listen, we all have an expiration date. We all will become ill, right? We don't know when nor how serious it'll be. I want to share a story with you. I had a client who called me and said that she had a woman who became my client, I should say. She called and she explained to me that she had procrastinated for years. You know, when I asked her why she finally, decided to give me a call, she said that her father-in-law had passed away. This was last year, so last year from COVID, and he had nothing in place. Then thereafter, sadly, her father died of COVID as well. So things were starting to hit way too close to home. And it was time for her to do something, as she put it, do something. She had attended one of my webinars. So I asked her, what was her strategy, if any, if something were to happen to her, and if she landed in the hospital. And she did not have a strategy at all. It's kind of like a deer in the headlights look. And at this point in the conversation, when people realize that just how vulnerable they are, she felt a little embarrassed. And it's one thing about meeting with me is that when you do, first of all, everything is confidential. And secondly, I want you to understand that it is a safe space. I meet people, plenty of people, who do not have estate plans. And I need you to understand that it is okay. It's my job to meet you where you are and get you to where you need to be. So, and I also want to let you in a little secret. I didn't always have an estate plan. I was a procrastinator too. But here's the thing. Once I did, it changed my life, and I changed my legacy by taking actions, and I am one person, I don't believe in coincidences. I believe that each one of you attending the webinar tonight or watching on the live stream, you were meant to hear the message that I have to share this evening. So I really hope that you are listening with intention to everything that I'm going to share this evening. So that we're all on the same page throughout this webinar, I want to address one fundamental question that I get from clients or potential clients all the time is, what is estate planning, right? Estate planning, it's documenting who you want to make key medical and financial decisions, right? During your lifetime, if you can't make them yourself. It's laying out in writing what you want to happen to your assets after you pass away. And then finally, it's deciding what you want your legacy to be and how you want to transfer generational wealth. Now, if no one in your family was able to leave an inheritance of any kind, in the past, perhaps you're going to be the one who's going to change your family's generational narrative. And we'll talk a little bit more about that later on. So just from that explanation, you can see how important estate planning is, right? You'd think that many people, especially now, in the midst of the pandemic, would go out and get an estate plan created. But here's a startling fact. Did you know that according to a 2021 Wills and Estate Planning study by caring.com, and that's a nonprofit for caregivers, only about a third of Black Americans have a will. A third. Let that sink in. White Americans are approximately at about like 35-ish%. And then here's another fact. A 2020 study done by the Brookings Institution examining the racial wealth gap between Black Americans and white Americans, they observed that high and middle income white families are much wealthier than Black families with the same incomes. The reasons that they cite are that white families receive much larger inheritances on average than Black families. Another reason they found was that high and middle income Black families are more likely than their white counterparts to be called upon to assist family members and neighbors financially. I found that quite interesting. So I first want to talk about 4 common estate planning documents, and then we're going to go into each one a bit more in depth. The first is a will. And a will is a legal document that sets forth your wishes regarding the distribution of your property and the care of any minor children. The next is a trust, and that's a legal document that allows a third party, known as a trustee, to hold and direct assets in a trust fund on behalf of a beneficiary. There are different types of trusts, and 2 common ones are a revocable and irrevocable trust, but there are others. And then a power of attorney, which is a legal document that allows someone else to act on your behalf. Powers of attorney can be helpful to older people and others who want to choose a trusted person to act when they cannot. And an advanced directive. And that allows you, it's a document that allows you to decide who you want to make healthcare decisions for you if you're unable to do so yourself. You can also use it to say what kinds of treatments you do or don't want, especially the treatments often used in a medical emergency or near at the end of a person's life. So we're first going to talk about wills. As I said, it's a legal document that states what you want done with your belongings, money, or other assets after you die. A will can also include your wishes about what happens or who will care for any minor children. Okay. Now, I've had people ask me about holographic or handwritten wills and whether they are valid. Maryland and the District of Columbia do recognize them, but they need to be written and executed properly. If not, there is a chance that the courts will not recognize them as valid. So will allows you also to name a personal representative. That's a person empowered by the court to settle your estate after you die. Now, why should you make a will, right? You decide who receives your estate, not the government. You can leave things to a spouse, children, friends, or charity. You can even set up what's called a testamentary trust. And it's, as I said before, there are different types of trust. And a testamentary trust is one that's typically used to leave something for a minor child. For example, I had a client who had a 17-year-old son. The client was concerned about giving a significant lump sum to her son all at once. If something were to happen to her, I should say. Now you can imagine that most 18-year-olds are not going to spend a large amount of money wisely. I advised her that she could defer those payments, half of those payments until her son reached 25, and then the balance at 30 as an option in a testamentary trust, for example. Beneficiaries do receive, or they're entitled to receive at 18 years old in Maryland, unless your will is set up to say otherwise. But that I share that as an example of creative ways that you can ensure that your child is not going to, run off to Cancun and blow the money that you've left for him or her over a weekend. You should also make a will, as I mentioned before, in order to appoint a guardian for minor children. Now, choosing a guardian is often the reason why people procrastinate in making their will. They can't decide who's good enough to raise their kids, which is understandable. But if you don't choose, the state's going to choose for you. And I'm sure that's not a decision that you want to leave to the state. You choose then there's a personal representative. You choose that person who is going to distribute your assets. That person is responsible for carrying out your wishes as you stated in the will. Now, some states refer to this role as an executor, but regardless, this is the person you choose to manage and oversee the administration of your estate. Now, you may have people in your family or friends that may want to help you with that. However, if your estate is very large and complicated and family or friends, are too busy to take on the responsibility, you can hire a company like a savings bank or a trust company to serve as a personal representative. This isn't an option that's used commonly among my clients, but I just want to share it with all of you that there is an option, because some people are kind of at a loss for who they'd like to appoint, and sometimes there's a corporate option. Oh, and one last thing before we move on. I have a free resource that I'd like to share with everybody who is on the webinar tonight and everybody who's live streaming. It's my free will preparation checklist. And if you go to my website at elsawsmithlaw.com and go to the resources tab on the website, you just provide us your information and we will send you a copy of the free will preparation checklist. Okay, the next tool that we use in estate planning is a trust. Now, there are different types of trusts, as I mentioned. The type of trust that will work for you will depend on your specific situation. And it is beyond the scope of this webinar to do kind of a deep dive into each one. But they're commonly used, I will say, to try to avoid probate. And probate is just the court supervision of the administration of your estate, court overseeing everything. If your primary concern is privacy, a trust may be something for you to consider. Now, common types of trust are revocable living trust, irrevocable trust, and testamentary trust, which you just heard me talk about just a few seconds ago. Today, I wanted at least to mention them so that when you do speak with an estate planning attorney, you're at least familiar with the terms. Your attorney's job is to fully explain what your options are and to answer any questions that you have in order to make an intelligent decision. So, what is a trust? It's a way of holding property. It is a document, but it is a way of holding property. It involves three essential players. One is the grantor. If I decide to put my property in a trust, then I am called the grantor. If I have investment that I need to manage, I'm going to transfer the ownership of that and title of that property into a trust. The trustee is the person who is going to manage those investments and that property for the benefit of, and here's the third player, the beneficiaries. So you have the grantor, the trustee, and the beneficiaries. The trustee's job is to read the trust document prepared and manage and distribute it according to those instructions. The beauty of the trust is that you can be both the grantor and the trustee while you're alive and you have capacity, meaning that you understand what's going on and you're able to think and reason and make decisions on your own. When you no longer have capacity, if you're using a revocable trust, that can be used to manage the property without going to court, assuming that you've named a successor trustee. If you haven't, then you do have to go to court and have one named, and it gets a little complicated. Now, a trust does not need to go through probate, and it is not part of the public record. So no one would know anything about your beneficiaries or assets that you're distributing if you use a trust. It's usually recommended that if you create a revocable living trust, you should also have what's called a pour over will. That's to catch anything that you may have neglected to transfer into the trust. That's to make sure everything is accounted for in your estate. After an estate planning attorney has had an opportunity to review all of your assets and discuss with you one-on-one confidentially what your goals are, you'll be in a better position to decide what type of trust is going to be in your best interest. In our office, we provide a prospective client with an extensive online questionnaire that gives us a real robust view of their estate, regardless of the size. The next tool is a power of attorney. Now, a power of attorney is a document that gives someone legal authority to act for another person. It allows you, and you're known as the principal, to assign a person who's known as an agent to manage your affairs if you are unable to do so. Now, to create a power of attorney in Maryland, you have to be at least 18 years old. You need to intend to give the power to a person that you designate in that document. You need to be mentally competent, which means that you're able to understand the document, the powers that you are granting, and which property is affected by that power. And by the way, the power of attorney is only effective while you are alive. So as soon as you die, the power of attorney is no longer effective. I have people that say, well, you know, the person's died, now I'm their power of attorney. I'm like, that's absolutely impossible. You cannot be if the person's dead. You are no longer their power of attorney. There is no power of attorney when a person's passed away. And then the fourth most commonly used tool is known as an advanced directive. Now, writing your choices down about your future healthcare at a time when you can still communicate those choices is going to help make your wishes carried out more effectively. For instance, an advanced directive is important when, say, someone is in a coma or on life support and unlikely to ever recover. Writing down those choices ahead of time can really spare your family members heartache, on whether to keep you on life support and for how long. Advanced directives can also state the types of treatments you want in different situations. Now, in Maryland, the advanced directive has two parts. Part one is where you actually name the agent, and part two is known as a living will. And the living will describes three distinct end of life or near end of life scenarios, and it asks you to choose the types or levels of care you want in each. And just for the sake of everyone watching, the three scenarios are if death is imminent, meaning you're going to die soon, very soon. If you're in a persistent vegetative state, think coma. That's the most common example that I use. And then the last scenario is when you're in an end stage condition, like cancer, but kind of end stage cancer. So unless a written living will says otherwise, it takes an advanced directive takes effect immediately. It takes effect when a physician and another doctor certify in writing that the patient is not able to make an informed decision about their health care. Let me clarify that. It can either take effect immediately or it can take effect when you're unable to make decisions about your health care. The way the Maryland Advanced Directive is written, you can have it take effect immediately, subject to your ability to, make your wishes known. It gives you a lot of flexibility. The document really speaks for you if you're unable to, and it makes sure that your religious and personal beliefs are respected. It's a useful legal document. It is not mandatory. It is an optional document, but it's something that I highly recommend for an adult of any age. An advanced directive is not just, for the elderly, for the senior members among us. I think everyone 18 years or older needs to have an advanced directive. So it's smart to think ahead, have one now while you are of sound mind, of clear mind. Now, to make an advanced directive valid, it needs to be signed by you in the presence of 2 witnesses who will also sign that document. If you name a healthcare agent, make sure that that person is not a witness, okay? Maryland law does not require the advanced directive to be notarized. You should give a copy of the advanced directive to your doctor, who should keep it in your medical file. And you should give another copy to a person that you trust, your agent, so that they can have it available when needed. I just want to put a little thumbnail here. Nowadays, it's so, depending on who your medical, what medical plan you're on or what carrier you have, you may be able to even upload certain documents to your medical file. So consider doing that as soon as you get your advanced directive executed. And copies are just as valid as originals. So now, as I promised, we're going to talk about estate planning for singles. Now, when I was, said in the promos, that we were going to talk about estate planning for singles, some of you may have been thinking that I was just going to talk about the 20 to 30-year-old sets. The truth is that one can be single at any age. You can never be married or suddenly single through divorce or widowhood. Okay. With an estate plan, as I said, there's a will, which will allow you to tailor who you want to receive your assets. And if you happen to have minor children, as I said, you can name a guardian. And you need to also update beneficiary designations, like on your bank accounts and so forth, insurance policies. And these can change as your needs change, right? And by the way, as I go along, you're going to notice a lot of overlap, but I want to focus particularly in this segment about singles. And a lot of stuff you'll hear me repeat again, but because it's relevant to both singles and people who are married.
I wanted to ask a question. Would you, Ms. Smith, would like to wait to the end or for questions?
I would appreciate that, just because it helps with the flow of the presentation, and some of the questions may be answered by the time I'm done. So if we could hold off the questions, I'd really appreciate it. Thank you. So if your accounts say that, say we're focusing on bank accounts, for example, and this is a single person. If your accounts say that a beneficiary is, your friend Joe, and if you have a will and the beneficiary happens to be John and not Joe, if it comes to your bank account, Joe is going to benefit. In other words, the person that's on the beneficiary designation, that's what counts. So make sure that there is consistency, between your beneficiary designations and a will. If you create one, and you should. It doesn't matter whether that you're signal, but you should have a will. You also are going to need a power of attorney for financial and medical decisions if you become unable to do so. And it's very important that the person you choose understands your wishes, and it's going to respect them when the time comes. When someone dies, their estate is possibly subject to estate taxes. And in some cases, the taxes can be very hefty and can take a significant amount of one's wealth. If this is a concern for you, you may want to consider other estate planning options, like a trust, and you can talk to your estate planning attorney about charitable giving as a way to kind of lessen the impact of estate taxes. And there are some single people who, may not have any living relatives or friends that they want to give their assets to. Now, in that case, there are many people who decide to give their assets to a charity or a nonprofit organization. I have clients that I've served who, give to their churches, their sororities, their fraternities, for scholarship funds or any number of reasons, but it's to an organization that has meant something to them, and it is a way of them of making an impact, and that's part of their legacy. You may feel that you may have no one to benefit from your estate, but there are always options. Remember that without a plan in place, your assets might go to people and organizations you didn't intend, and who you would not have selected could be making important decisions for you if you become incapacitated, as a single or otherwise. Now, this is a question I get a lot. What documents do I need if I'm in the hospital? Now, again, this is the single person. The truth is that it's a little late to think about this when you're in the hospital. Let me be frank. The time to plan is when you're not in crisis, right? So what are the immediate concerns if you are in the hospital? We just reviewed some of the tools that are commonly used in estate planning, and I hope that you were taking notes. So the first concern is advocating for your care if you cannot. So I'm guessing, and those of you who have taken notes should be guessing that you need an advanced directive. We need to think about who you want to speak on your behalf. Now, remember, in this case, there's no spouse in the picture. So you have to choose someone else to be your healthcare agent. But who? It can be a trusted friend, adult family member, or someone else, someone who will have your best interest in mind and be willing to carry out your wishes regarding the kind of care that you want or don't want. And the next immediate concern is paying bills. Okay, can everybody hear me okay? Yes? Okay.
Yes, we can hear you now.
Oh, did
something happen? You were muted.
Okay, let me start off then from the top, then from this slide, just for accuracy. This is a question that I get a lot, is what documents I need if I'm in the hospital, if I'm a single person. And what I said was, if you're talking about who's going to advocate for your care, if you cannot, then yes, you're going to need an advanced directive. And those of you who guessed that are correct. You need to think about who you want to speak on your behalf. And as I said, remember that in this case, there's no spouse in the picture. So you have to choose someone else to be your healthcare agent. It can be a trusted friend, an adult family member.
We can't hear you, Ms. Smith. You're muted.
Somehow someone else muted me while I was in the middle. I don't know who, but someone else muted me. I know that I'm unmuted now, so let me keep going. So the next concern, while this is the single person scenario in the hospital, is paying bills and handling your affairs. So if you guessed that you need a power of attorney, again, remembering the tools that we covered a little while ago, you're right. While you are in the hospital, you need someone with legal authority to pay your bills. So how exactly does that work? The power of attorney, and it is a document, the power of attorney agent uses that document. They have to have that document and say they go into a bank, they present that document to the bank and say, I'm here acting on behalf of Jane Doe. And they can withdraw money, they can deposit money, they can do anything that you would legally be authorized to do. They are stepping in your shoes. And it is a very, very powerful document. They can sign contracts on your behalf and just about anything. So to review, in this situation, you're single in the hospital, you're going to need at least 2 documents. And we said that they are the Advanced Directive and the Power of Attorney. So now we're going to talk about estate planning considerations before saying I do. Now, at a minimum, you should be discussing the following. What are you bringing into the marriage? The good, the bad, and the ugly. Okay, now you had a life before you met your fiance. You may have been working for a company that provided you with life insurance, maybe a retirement plan, a 401k if you're in the government, a TSP. But for those couple benefits that I mentioned, you would have had to name a beneficiary, someone that's going to receive whatever is in that pot when you pass away. You need to consider if and how those beneficiaries need to change once you marry. And it is, I may be striking a nerve here, but it can get kind of touchy, because you may not want your spouse to have everything. Some people do by default say, okay, honey, everything I have is yours. But some people have come into the marriage saying, well, I want this pot over here to go, half to you, darling, and half to whomever. But that is a discussion that needs to be had, and all the stuff needs to be laid out on the table about who's gonna get what. But that is something that you need to do, or at least consider, because here's the thing. If I'll give you an example, and this is like the nightmare scenario that I usually talk about when it comes to life insurance. Say that this is not your first marriage. Say it's a second or third time around, and you have a life insurance plan that you took out many years before you met your current fiance. Your life insurance policy has ex-spouse number 1 as the beneficiary. You get married, you pass away. Guess who's getting the proceeds of that, say, $1 million life insurance policy? You got it. Ex-spouse, number 1, numero uno. And the life insurance and the insurance company will be well within their rights to cut that $1 million check to that ex-spouse that your beloved had not talked to or whatnot, and you get left with lint, nothing. So I tell people over and over again, update those beneficiary designations, please, because you do not want this to happen to you. And they go, Attorney Smith, I'm going to run to court. And I said, and the court will just say, what's on the beneficiary designation? It's as simple as that. That's how serious it is. And that's, I said, the nightmare scenario. So I talked about, the good, the bad, and the ugly, right? So we talked about the benefits, all the good stuff. Now let's flip it and talk about the other side. Do you or your fiance have debts? What kind are they? Can those creditors come after your assets after you get married and you start pooling stuff together in the same pot? As with most answers attorneys give, the answer is it depends. If you have separate bank accounts while you're engaged, your fiance's creditors cannot come after the funds in your individual bank account. Now, once you do marry, and if you were to open a joint account, meaning all the money that's in that pot belongs to both of you, then that money is at risk from your new spouse's creditors. Okay, so keep that in mind. Next thing to consider before saying I do, and trust me, this is not an exhaustive list, but I do want to mention these things as they come up and I share them with clients and prospective clients, is how will your existing estate plan change? Now, this assumes that you had an estate plan to begin with. And, my hope is that people do, but more often than not, they don't. And that's okay. That's why they see people like me. The truth is that every adult needs some sort of an estate plan. Estate planning is not just for the wealthy, and it's not just for married folks. Estate planning is about protecting your quality of life while you're here and providing for those you love when you are not. So think about whether beneficiaries will change, once you marry. Now, let's talk about incapacity. All right. Who will be the key decision makers in case of incapacity? No one likes to think about this because it's unpleasant. You're busy thinking about the guest list for the wedding, the type of dress you're going to wear, and where you'd like to honeymoon. But I need you to consider who you want to make medical decisions for you before you get married. And will that change when you do get married? And by the way, none of the documents that we've mentioned are, permanent. They're not etched in stone. You have the right to change your mind about who you want in certain roles. So it's a tragic picture, but picture this. Again, we're talking about on the eve of saying I do. 5 months before your wedding, you get into a serious car accident. You're airlifted to a trauma unit. You are still alive, but you're on a ventilator in someone's ICU. Life does not stop because you are in the hospital. You're not married yet, so your fiance doesn't have the rights you think they might have. Okay, you are still single. Again, remember the things we talked about in the single person scenario. The doctors are not allowed to share your medical information without your authorization. That's because of what's known as Hipaa Privacy Law, and Hipaa stands for Health Insurance Portability and Accountability Act. It's a federal law, a privacy law. So also, you're going to need someone to pay your bills. Again, you're in the ICU. You need someone to pay your bills, handle your affairs. Is your fiance the person you want making those decisions for you? Or do you think perhaps a sibling or a parent might be more appropriate? Okay, you're not married yet. So things may change once you do get married, but it's so crucial to just have a plan beforehand. If you want your fiance to make those decisions for you, that's fine. You just need to name him or her on the Advanced Directive that I hope that you would consider, having created. It needs to be in writing. There we go. Now, estate planning considerations for married couples. First thing are wills. Yes, we've talked about wills quite a bit. And of course, that is something that married couples need to consider. Now, a question I get often is, oh, can my new husband and can we just create a joint will? The better practice is for each of you to have your own will. And here's why. Just like the Social Security Administration issues everyone their own Social Security number, everyone needs their own will, because it's a lot less messy if something needs to change in the will. And it's just easier from an estate planning standpoint for each person to have their own will. And most newlywed couples enter their marriage without an estate plan at all or a will. If you do come into a marriage with a will, it's important to update that will to include your new spouse. Drafting a will is an important piece of financial planning as well, because it helps couples make decisions such as determining who needs to be nominated as personal representative and how the assets should be distributed. Comprehensive estate planning would also cover, as I said, arrangements for children, naming a guardian, and establishing possibly a testamentary trust. Now, this is something that's going to be particularly of interest because it's fairly recent. It's called the Elective Share Law. Maryland protects spouses from being disinherited from the other spouse. The rule of law called the elective share gives the surviving spouse the right to receive a fixed amount of the deceased spouse's estate. The purpose of this law is to ensure that the surviving spouse is provided for within reason for the remainder of his or her life. The public policy, behind this is that, it was a protection of, widows. They didn't want to see widows out on the street. So that's kind of where the public policy argument is behind that law. A surviving spouse can choose to either take what is left to him or her under the decedent, the person who died, the decedent's will, or claim that elective share and receive a fixed amount of the decedent's estate. Now, as the term implies, it's elective, it's proactive. You have to inform the court that you want to exercise that option, and it has to be done in writing. If you don't, then, you're basically stuck with, what's in the will. So there needs to be, an action on your behalf. The spouse's right to the elective share is absolute unless it was waived through a prenuptial or postnuptial agreement. So you need to consult with an estate planning attorney for more information on how the elective share affects you in your situation. Next thing, updating your will. If you have a will, update it, be specific. Be specific if you want your children to inherit certain items. So if you don't, your spouse can attempt to claim ownership of certain items, or your children can end up fighting about it. And it's just, it's just awful. So what do I mean? You need to say, I leave my 3-carat diamond engagement ring to my son, John, and my, cherished heirloom, china, to my daughter, Jennifer. Okay. You need to be very specific about what items, and it does not have to be, an exhaustive list, but the things that really mean a lot to you, art collections, music collections, cars, for example, you need to be very specific. Otherwise, it's just going to create chaos among those that you leave behind. Now, a word about adopted children and stepchildren. Stepchildren don't automatically inherit under your will unless you adopted them and go through that legal process and that adoption is finalized. Adopted children don't have that issue. Formally adopted children, under the law, under Maryland law, they are removed from the inheritance bloodline, if you will, of their biological parents, and instead inherit from their adoptive parents through, if there were no will, through the laws of it's called intestacy. That means dying without a will, you're dying intestate. So that's what happens with adopted children. So if you have stepchildren, you need to make sure that you specifically identify them in the will. Don't just say my children, because that's not going to cut it. And you don't want to, if your intent is not to disinherit a stepchild, then you want to make sure that you specifically name them in the will. Now, powers of attorney. Along with the wills, and estate plan should include a power of attorney and an advance directive. These forms, are used to make financial decisions, and of course, the healthcare directive is for medical decisions, and they're usually used together. Where there's one, chances are that there is another, because people. It's just generally a good idea to have both in place, just so that your wishes are in writing. You have a clear directive over who you want to handle your affairs when you can. Then the other thing that married couples should consider are trusts. We talked about trust before. I said that there are different kinds, but I just want to mention a couple of, or an advantage of establishing a trust. It can be a good option for couples, say, who own separate property, either from previous marriages or relationships, or even from a family inheritance. They may also be beneficial if you have a prenuptial agreement that already dictates that property and earnings should be separate from one another. A downside of a trust is that it can be a bit more expensive, and administration can be a bit more complicated. So it should not be surprising to a lot of people who want a trust-based plan to have a bit more of a heftier investment on the front end, because it is a more complicated document. And then if you're hiring a firm to help you administer the trust, it can get a little bit more complicated. It's useful, but it depends on what your needs are if you're willing to make the investment for it. So again, just something to consider, and something that's worth talking to an estate planning attorney about. Now, let's talk about folks who are getting remarried, trying it again. You may have created an estate plan during your first marriage, but this time it might be a little bit more complicated. Why? Because you may have children from the first marriage, or you may own more assets. So please note that there is going to be some overlap over what you consider. I've talked about certain things that you should consider as a single person. And yes, there is some overlap, but that's okay. The first thing I need you to consider is, take an inventory. List basically all of your assets and debts and share it with the other person. Don't forget to include life insurance policies and retirement plans in that inventory. It's important to really be honest and open about money if you want to prevent bad feelings between you and your significant other, your spouse, in the future. Then decide how you want to handle finances. Once you know what you're dealing with, you need to decide if you want to combine or not combine certain assets when you're married. For example, if one spouse is selling a house and moving in with the other partner, will he or she contribute to the cost of the house? If one spouse has significant debt, you may not want to combine finances or make any joint purchases. These decisions need to be made up front so that everyone is clear on what to expect. And I really wanted to touch on this because this is a financial wellness seminar. So it's really important to think about that. And there's the finance world and the estate planning world. There's so many intersections. This is absolutely relevant. So the last thing in the remarriage situation is decide what happens when you die. You and your future spouse need to figure out where each of you wants your assets to go when you pass away. If you have children from a prior marriage, this can be a complicated discussion. Okay. There's no guarantee that if you leave all of your assets to your new spouse, that he or she will provide for your children after you're gone. I hate to say it, but it's true. Okay. But it needs to be said. There are a number of options to ensure that your children from the prior marriage, if that's what we're dealing with, are provided for. It could include creating a trust for your children, making your children beneficiaries of certain life insurance policies, or giving your children joint ownership of property. You know, even if you don't have children, there may be family heirlooms or mementos that you want to keep in your family. Again, open discussions can prevent a lot of these problems in the future. Trust me. I've seen a lot over the course of the time that I've been representing people on estate planning matters. Now we're going to talk about what not having a plan costs you. You rob your family of peace of mind because they are left to deal with the mess you left behind. And now let's talk about probate and what it is. Probate is a legal process that takes place after someone dies. It includes proving in court that a deceased person's will is valid, and that part is usually routine. Probate also involves identifying and inventory a deceased person's property. It involves having that property appraised, paying debts and taxes, and distributing any remaining property as the will dictates, or if there's no will, according to state law. So I just want to put a thumbnail here that if the only thing that you have is a will, yes, it will go through probate. That's not necessarily a bad thing, because fortunately, Maryland has a pretty streamlined process of processing an estate. There are options for you, as I mentioned, a trust, if you just want to bypass that altogether. Dying without a will is known as dying intestate. You've heard me mention that term once before. That's what that means. And talking about probate involves paperwork, yes, and court appearances by lawyers. And typically the lawyers and the court fees are paid from the estate's property, which would otherwise go to people who stand to inherit from that property. It's a cost of administering the estate. The other thing that not having a plan costs you is you don't get to choose who's going to raise your kids. The court is going to need to appoint guardians. This process is lengthier if the court has no guidance as to who you want, meaning you don't have a will, you didn't create a will. So the court's going to have to choose. When it comes to kids, the standard is usually what is in the best interest of the child. So you may have, this long lost relative who happens to be well-to-do, but is really not the ideal person that, you would have chosen to take care of your kids. And they show up rolling in going, Your Honor, we are best suited to take care of little Jane and Johnny. Meanwhile, little Jane and Johnny are in terror because they're like, who is this person? I've never met them, and why do they want to take care of me all of a sudden? You don't want to put your kids in that situation at all. And then the last thing is that your legacy is tarnished or ruined when you don't have a plan. I cannot tell you how many times I have seen people who have passed away. They have no life insurance, no will, no nothing. And then somebody has to start a GoFundMe campaign on Facebook to raise money. And I'm honestly not trying to shame people who, have no other options and something happened all of a sudden. But for those of us who are on this webinar, who are listening to the live stream, you have time to plan. There is no need for us to resort to these types of fundraising efforts when all of this could have been taken care of by proper planning ahead of time. So you save your family and friends the embarrassment of basically tipping their hat and asking people to just, put money in a hat to pay to have a decent funeral for your loved ones. We can do better. And as a community, we should do better. I'm hoping that we do better. Okay. Now, I want to share this story. It's based on a true story, but I've obviously changed the names to protect the people involved. This is about a former client, and we will call her Christina. Christina met me during one of my live estate planning seminars. Of course, this is pre-COVID. She later hired me to update her estate plan. She was single, no kids. She is a medical professional who had an old estate plan from about 15 years ago. She wanted to make sure that her younger adult siblings were taken care of. A problem that we encountered was that one of those siblings had a real serious problem with managing money and just his life. He was just a hot mess. But she loved him in spite of it all. Her old estate plan made no provisions for him. Now, mind you, this is her sibling, so she has no legal obligation to provide anything for her siblings. Let me just establish that. But her old estate plan made no provisions for him. And the truth was that, she was in a different place emotionally. She had a very different relationship with that particular sibling. They were very distant. When we met at my office, we talked about the legacy that she wanted to leave. And I wanted her to give this some real serious thought. We talked about the options available to provide for her younger brother that would show him that she still loved him, but structured the plan so that he would have amounts dispersed to him over a period of years instead of all at once. We not only, created a new will, but also updated her power of attorney and advanced directive. Her 15-year-old will no longer worked for her because it did not reflect the kind of person that she was today. And it didn't reflect the relationship that she was hoping to have with her siblings, right? A few weeks later, after working with us, she signed her newly drafted estate plan. The look on her face holding her estate planning portfolio with all of the new signed documents was priceless. She felt so relieved that she was able to get this done. She had been procrastinating because she didn't like addressing the sibling issue, as well as some other things. Now, I listened to what she wanted and then recommended options tailored to her individual needs, right? Christina looked as if a 2-ton weight had been lifted from her shoulders, right? She did it. So we've spent time looking at, how chaotic and stressful your life can be without an estate plan. We also talked about what singles and couples need to consider. We also talked about the different tools that are available in estate planning. Now, most of you would agree that you don't want to live in a state of overwhelm. And we can agree that you don't want your legacy to be one of discord, disorganization, and just anger amongst those you leave behind because you failed to plan. And we can also agree that just hoping, hope is not a strategy. I think we can agree on that. Now, I want us to look at what life could be like if you decided to change the narrative in your family for the better. If you came from a family, like a number of my clients have, where no one had an estate plan, no one had a will, No one had anything. They just kind of, threw caution to the wind and said, well, the family will somehow figure it out. If that's you, the change can begin with you. You have the benefit of having a plan is that you have structure, you have a plan that identifies who will make decisions for you if you end up in an emergency room and can't speak for yourself. You'll know exactly who you want to serve as guardians for your children if you die. You have someone in place who will have the legal authority to pay bills and handle other business for you if you cannot. And for the first time, you'd have a plan to give back to organizations and the people that have helped you during your life. You'd be a role model for your kids because they're seeing you taking responsibility for your life as well as theirs. And then most importantly, you can rest, not just sleep at night, because you've done what you can to protect yourself, your family, and your legacy. Now, as I said, I have a special offer, and I hope that you are ready to take action after listening to all this helpful information. And for those of you who have your cell phones out, I want you to take your cell phones out and text the word estate to 55444. What's going to happen when you do that? Only during today's webinar, you will receive $200 off of an estate planning consultation with our firm. And that it is if the consultation is confirmed by October 15th, 2021. This offer cannot be combined with any other offer, and it is not transferable, meaning that if you're on tonight and you want to give the benefit to your neighbor, it's not going to work. Everybody has to be on the call, and it's only good tonight. Again, text the word estate to 55444, and you can even put that in the chat, to a moderator if you so wish. Text that to 55444. You'll get an instant message. And you will be entitled to receive that significant discount off of an estate planning consultation. The text will instruct you to call our office during business hours and secure that consultation. I want to thank Abounding Grace Church International for the invitation to participate in this financial wellness series. Thank you, Pastor Lawrence Patterson. Thank you, Pastor Sharon Patterson. And I want to thank each of you watching who made an investment in yourselves by attending this evening. You're worth it. Now, my question to you is, what are you going to do about it? I'm Elsa W. Smith, and it has been my honor and pleasure to present to you this evening. I will now stop sharing my screen and turn it back over to our senior pastors.
Thank you so much, Ms. Smith. That was a wealth of great information that you provided, terms that I'm not even familiar with, but know that I need to get familiar with. So I'm going to also utilize the text and see if I can, fill the gaps in this particular financial portfolio. We do have some questions in the chat, and I would like to open the chat for others who may want to ask questions. This particular question said, what happens if a parent has sole legal and physical custody of a minor, and the minor's custodial parent wishes to have someone other than the non-custodial parent as the legal guardian in their will? Does the will withhold that wish?
Very interesting question. What I do know about this is that the law views, unless one of the parents, their rights have been terminated for some reason by the court, the court views the biological parents as natural guardians. So the court could absolutely consider the other spouse first. And unless there is some legal reason or some other reasons why, as far as I know, that other parent will get first preference. But again, there's probably details I'm not aware of, but as far as I know, like I said, unless the parent's rights have been terminated, the court would consider the other parent, even though it says otherwise in the will, which is what the question deals with. They're going to look to the other parent. The court's going to ask, well, is the other parent alive? Start there, and then say, well, has that other parent's rights been limited, terminated for some reason? And if not, then it'll go from there. But they're not. But the important thing is that they are under consideration by the court. They're not automatically out of the equation because they weren't in the deceased will.
Okay. The next question is, what is the criteria for a handwritten will valid? How do you find out?
Okay. In Maryland, for what you need for a will is for it to be, well, first of all, the person signing the will, the person creating the will, needs to be of sound mind. They need to be aware, it can't be, a person who's like in a coma or whatever, and you can't just move their wrist in order to get them to sign. That's not valid. The person needs to have the intention to create the will, be of sound mind. The will needs to be witnessed by two people, two adults, witnessing the signing of the will. They don't need to know what's in the will, but they need to be in the same room with that person who is signing the will. In Maryland, the will doesn't need to be notarized. So as long as, those criteria are met, technically the will is acceptable. Now, here's the thing. People say, well, sure, I'll just, write my will. The problem with that is that you open yourself up to challenges because, people can, make changes to, handwritten wills and so forth. And it's just easier I guess you're saving yourself headaches by not using a handwritten will, just doing, having it, either going with an attorney. You don't need an attorney in order to create a will. You should, because you don't know what you don't know, but you just open yourself up to people challenging the will when it's handwritten.
Okay. And this is the last question that was in the chat while you were talking. So I want to make sure that they are able to get their questions asked.
Sure.
This one says, should you have a certain estate value before considering a trust?
That's an interesting question. I wouldn't say necessarily of a particular value, and I don't want to just spout a value out there because really there isn't. It all depends on whether you are seeking to shield a particular asset from creditors. Now, not all trusts provide that kind of protection, but if that's what you're looking for, and if you're willing to, if your goal is to put as much into the trust as possible, it's up to you now to make sure that the assets are retitled as necessary into the trust. It does cost more to have a trust-based plan, regardless of whether it's revocable, irrevocable, or any other trust. If it's a trust-based plan, by comparison, it's going to cost you a little more on the front end than a will-based plan because it's a bit more extensive. to prepare. That's really the reason. And you need to consider whether you have the commitment to make sure and transfer assets to the trust. Because here's the thing, you can pay an attorney to create this trust for you, but if you don't transfer the assets into it, it's nothing. It's a worthless piece of paper. And if your goal was to avoid probate by putting all the things in trust and you didn't, it's for naught. You're going to end up in probate anyway. And you've paid more. Not that, that creating a trust is a bad thing, but if you're not going to do your part in transferring it, it's for nothing. You just should have gone with a will-based plan if you weren't going to have the commitment to transfer what you need to the trust. Now, you can pay a firm to do that for you. That's going to cost you more. But if you're willing to do that, fine. But if you're not, just, be realistic about what you're able and not able or not willing to do when you meet with an estate planning attorney. They're going to present the options to you. And people are like, oh, well, I want to trust. And when I explain, okay, this is what the investment is. And people are like, oh, well, it's another level of protection. And here's what you're going to be required to do. So if you're able to do that, I'm very upfront with my clients about what options they have available to them and what are their responsibilities once they exercise an option.
Thank you so much. And I see that someone else has their hands raised. I think it's Ms. Diane.
Hi. Hello, everyone. Hi, Ms. Smith.
Hello.
I got a question for you. Several years ago, my dad had a living will, and of course he didn't sell mine. He had several properties in addition to homes and things of that nature, but he had one particular home that he left to the siblings. And what my brother did is he went in there and he remodeled the home, and the wife got everything except the home. And she protested the home and got half of what the home was worth, because my brother went in there, he spruced the home up, so the value of the property went up, and she ended up with half of what the home was worth. Could you elaborate a little bit on that?
Actually, it wouldn't be appropriate because that's a little bit more, that's something that's actually suitable for a consultation. It's something that's not really appropriate for me to discuss here, in public. So you are more than welcome, take me up on that offer, because that's a significant discount from what a standard consultation is. And I'd be more than happy to explore that with you, but it's just for decorum purposes and confidentiality purposes, quite frankly.
Yeah, that's true.
Yeah.
Exactly. Well, thank you so much. And
Absolutely.
I really enjoyed it. Yes, ma'am.
You're welcome.
Do we have any other?
I see another hand up. Miss Davis, is it?
Yes. Hi. How are you?
Hi. Good. Thank you. I can't see you, but I know that you're there. So.
I am here, and I have been here. Thank you.
You're welcome.
And I've been taking lots of notes. And you mentioned a testamentary trust.
Yes, ma'am. Yes.
Would that be something that I would do for my grandchildren?
You certainly can. And I'm glad you asked about it. A testamentary trust. It is unlike the revocable living trust or an irrevocable trust that I mentioned, which are separate documents. The testamentary trust is actually a part of your will. So you can actually have it inside the will. It doesn't come into being until after you die. Right. So it, it would still need to go through, the probate process and whatnot. And it would be up to your personal representative to create the trust, meaning create a bank account to house whatever it is that you want there in that bucket for the benefit of your grandchildren. But absolutely, it can actually work. And I had, you actually brought to mind a former client that I had who had several grandchildren, different ages, and we had to stagger the distributions for each grandchild. But it was absolutely possible to do that. So yes, testamentary trusts are an option. Absolutely.
Thank you.
You're so welcome.
Does anyone else has any questions for Mrs. Smith?
Yes, I do. I'm Karen Reed. Good afternoon. Oh, good evening.
Good evening. Hi.
So much. This has been so wonderful. I mean, it really gives you a lot to think about. I don't have my video on, but anyway. Yeah.
Your picture is lovely.
Yeah, okay, here I am.
There you go.
Hi. It really, really gives me a lot to think about. I mean, like, I'm so organized and this, so I mean, I really, really love having things like in place, so this has been great. But I'm in Georgia. So will that help me? Am I able to do things over the phone, or I would have to probably see someone in Georgia?
Well, when you say you're in Georgia, are you a resident? Are you now living in Georgia, or are you just visiting?
I live in Georgia.
Okay. Yes, then you absolutely would need to have a Georgia attorney, estate planning attorney, create those documents for you. Yes. Mm-hmm.
Okay. Well, thank you so much. I appreciate this.
You're so welcome.
Okay.
Thank you, Karen.
Okay.
This
Okay.
is great.
Someone is asking me to read their question in the chat.
Oh.
And it says, my husband died and I had a will. My name was not on his car. He had the car when we got married. I had to go to probate just to cancel his car insurance policy and sell his car.
Mm-hmm.
I'm not sure what the question is.
I don't know.
Okay, we'll come back to that.
Sure.
Carrie Jean has her hands raised.
Okay.
Actually, this is going to be Lewis this time.
Hello. Hello, Lewis.
Hello. Question. Once you get married and you live in one state, once you actually get everything notarized and have a lawyer sign papers and you move from state to state, do you need to update those documents?
That's an excellent question, Lewis. It is always a good idea to have an attorney in the new state of residence review your documents. Now, say, for example, you used to live in New Jersey and you had an estate plan done in New Jersey, but now you are living in Maryland and you had you had a will done there, but now you're here in Maryland. Maryland will honor the will as long as it was executed according to Maryland's requirements. It will be adopted. Same goes for like a power of attorney. If it was created and executed according to Maryland law, it will be honored. But it's always a good idea if you've made the investment to relocate to another state, invest, an hours a time meeting with an attorney in the new state just to put eyes on your estate plan to see whether there's anything that needs to be tweaked, because you don't want to get caught off guard. Great question.
Thank you so much.
Yeah, thank you for asking it.
Thank you so much, Louie. I think the person was saying about the car, if I can remember, is that she had a will, but the insurance policy wouldn't honor the will to cancel the car insurance. I think she's saying even though she had a will, the car insurance company did not honor the will, and she had to, and the car went into probate.
Well, if there are assets that are in the sole name of the deceased, then they do need to go through probate. Let's say if there's a house that's only in the name of the deceased, Maryland, not yet anyway, we don't have what's called like transfer on death, TOD deeds. We're not there yet. We're trying with the Maryland State Bar and other state planning attorneys, we're trying, but we're not there yet. So yes, if any property asset that's in the name of the decedent, unless it's put into a trust, it does need to go through the probate process. And with regards to cars, I know there's a process through the DMV, switching titles and so forth. But yeah, it does need to go through probate.
Thank you so much for that. Wow, this has been great, Mrs. Smith, having you here and discussing all the nuances of estate planning. And I believe everyone had the opportunity to ask questions.
And I just want to say one other thing is that everything, I know that I've answered questions. I'm licensed in Maryland and DC. So if it's, a question regarding another state, that's why, the young lady who's from Georgia, I'm not licensed there. So I can't obviously give advice on, out of state law. And I would advise you to really just make the investment. There's a saying, don't be penny wise and pound foolish. We need, what I'm hoping, and pastors, if you'll indulge me for just a second, I really hope that we as a community of us, we normalize having professionals in our lives. We go to the doctors, right? We go to dentists, we go to specialists. You need to start normalizing a conversation of, talking to estate planning attorneys, talking to financial planners, financial advisors. We should not do things when we are in a state of crisis. And that is my plea to every single one of you, with whether it's me or another estate planning attorney, just do something. You've got all this information. What are you going to do with it? Okay, thank you.
Thank you so much. And this concludes our financial clinic. I would like to ask if Pastor Lawrence have anything he would like to say.
Thank you so very much. I'm Pastor, I'm Sharon, and certainly Attorney Smith. I mean, we were so richly blessed by what God has given you to give us today. As you said, and I believe an informed community can do far much more than an uninformed community. And what you brought to this space for us on this evening is very rich. And I have so many notes here. I felt like I was in two spaces as you and I talked earlier, but this was certainly a rich space for me to be in because it had so much information that I know me and my wife will need to continue to talk about, as well as continue to educate our congregation in this area as well. So again, thank you so much for laying it all on the table for us on today, and God bless you richly for coming.